We have 6 judicial nominees, 1 executive nominee. I'll be supporting Jennifer Reardon. Ms. Reardon has spent her career litigating at some of the best law firms in the country. She's familiar with the types of cases in the Southern District of New York. Finally, take a few minutes to discuss Judge Jackson's nomination. Judge Jackson, of course, was very personable and engaging. I enjoyed the opportunity to meet her family before the hearing started. We obviously are, they obviously are, and should be proud of her achievements. Having carefully studied her record, unfortunately, I think she and I have fundamental different views on the role of judges and the role that they should play in our system of government. Because of those disagreements, I can't support her nomination. Over the last several weeks, I've talked about how the White House and Democrats have shielded important parts of Judge Jackson's record. We don't have any non-public documents from her time at the Sentencing Commission. The Obama White House held back more than 48,000 pages. Judge Jackson also gave the White House confidential, non-public probation recommendations for some of her cases. But last week, we asked for other documents having to do with probation filing in the Hawkins case. Judge Jackson told us that she can't get records for her old cases because she's no longer a district court judge. That seems to be very convenient. However, it is a big inconvenience for this senator. The refusal tells us that those documents probably wouldn't help the nominee because we've seen the willingness to leak any helpful information. So senators have to make a decision on her nomination based on the information we have. As I said, when this all started, we would thoroughly examine her record and judicial philosophy. We've done both. In the last few weeks, we've heard the remarkable arguments from Democrats that we shouldn't consider a nominee's judicial philosophy in voting. Democrats have themselves to blame. After vicious, misleading attacks on Judge Bork and other conservatives, Republicans didn't use those same tactics against nominees of Clinton, Ginsburg, and Breyer. Then, you know the history. Senator Schumer decided to bring back attacks on judicial nominees based on judicial philosophy and also on ideology. In a June 2001 op-ed, Senator Schumer pointed to Bork's nomination and argued it would be good to return to, quote, a more open and rational debate about ideology when we consider nominees, end of quote. He clearly thought the Bork nomination was a good model. Over the next few years, Senator Schumer put his Bork strategy to practice. In 2003, he even said he was proud of his role in blocking nominees based on ideology. So a question to Senator Schumer, 18 years later, are you still proud that you poisoned the water on judicial nominees? Now, he and other Democrats think it's unfair that we looked at Judge Jackson's record and asked her about it. That doesn't hold up to even the slightest scrutiny. Senator Schumer and Democrats decided to destroy the model of deference if a nominee was qualified, excluding considerations of their philosophy. In other words, Ginsburg and Breyer are models for that, and they don't think that's a good model. So that's why judicial philosophy has focused on judicial nominations. Now, at one point in written question to her, Senator Cruz posed this question: please explain in your own words the theory prevalent among members of Founding Fathers' generation that humans possess natural rights that are inherent or inalienable. She seemed to have an understanding of this when she answered by saying the theory that humans possess inherent or inalienable rights is reflected in the Declaration of Independence, which states, "We hold these truths to be self-evident, that all men are created equal, that they're endowed by their Creator with certain unalienable rights, among them life, liberty, and the pursuit of happiness." Then in the next question, do you hold a position on whether individuals possess natural rights, yes or no? It seems to me what her understanding that she should have easily said yes to that. But she took a position, she didn't have a position. So part of having judicial philosophy is having an understanding of the fundamental principles in our Constitution. Natural rights are part of that system. But as Judge Jackson said in a written response, she does not, quote, hold a position on whether individuals possess natural rights, end of quote. I take issue with this, as natural rights are basic to our constitutional system and principles of limited government. Under our Constitution, we're endowed by our Creator. Well, I don't have to repeat that. All other rights are reserved to the people under the 10th Amendment. Recognizing the principle of limited government is what makes America the exceptional government compared to all others, and obviously sets our Constitution apart from all others. When interpreting the law and the Constitution, understanding the principle of limited government are essential. Otherwise, there would be no checks on the federal government. So does she have an understanding of the meaning of the 9th Amendment and the 10th Amendment? At her hearing and her meetings with senators, Judge Jackson explained that she does not have a judicial philosophy, instead looked at her methodology. She said to look at her cases to see that methodology worked. I did, and I found the results of that methodology alarming when Judge Jackson applied it to the First Step Act. At the hearing, Judge Jackson testified about compassionate release provisions of the Act. Senator Cotton walked through the specific cases, that of Keith Young, where Judge Jackson misused a motion for compassionate release to resentence and do it to a dangerous drug kingpin. As the lead author of the First Step Act, I know a thing or two about compassionate release. It's meant to allow elderly inmates and those suffering from terminal illness to petition the court for a sentence reduction. The statute also allows for reduction if the court finds an extraordinary or compelling reason. This is supposed to mean that it's be a rare instance and use it with great discretion, particularly as weighed against the charge, danger to society, and the risk of recidivism. At her hearing, Judge Jackson said that she based her extraordinary and compelling findings on the non-retroactive change in the law. And of course, this is a terrible and dangerous misinterpretation. Congress chose which provisions of the First Step Act would apply retroactively, and since I'm involved with that legislation, I ought to know. The Senate is currently considering legislation that I co-sponsored with this chairman, Durbin, that makes some of the First Step Act retroactive. But Congress must make that change because the First Step Act didn't provide for retroactive application in all instances. For instance, retroactivity isn't mentioned once in the compassionate release statute. The relevant sentencing guidelines don't mention retroactivity as an extraordinary and compelling reason either. So Judge Jackson's consideration of applying retroactivity to the First Step Act when it's not explicitly provided is extremely concerning. It's a radical position, and it's outside of the confines of law. Judge Jackson's interpretation was so extreme that she got Senator Cotton to even defend the First Step Act. I don't think that's what the White House had in mind when they said she was a consensus builder. The other troubling part about this case is that Judge Jackson gave a different explanation for her reasoning in the sentencing hearing than she did before the committee. She found that Mr. Young's health and COVID were extraordinary and compelling reasons that warranted the reduction in the sentence. But the reasons have to justify the reduction. Reducing his sentence based on current health conditions and a pandemic, but leaving him in prison for another 7 years makes no sense. Here, it meant that Judge Jackson got to sentence the defendant to the sentence she wanted to do all along. The compromise that I brokered with Senator Durbin on the First Step Act and many others wouldn't have been possible if we thought that the activist judge would insert their own views into the law. Decisions like this represent serious separation of power concerns and will make bipartisan work harder in the future. Young is just one example of Judge Jackson's lenient approach to criminal law and sentencing. She's declined to apply a number of sentencing enhancements Congress put into the sentencing guidelines. I've worked to reform sentencing for nonviolent offenders, but Judge Jackson's approach applies across most areas of criminal law. She has consistently applied minimum sentences for dangerous crimes. Another case shows that Judge Jackson can apply her methodology to reach a result that goes against the plain meaning of the statute. The case is Make the Road New York. It involves a question over meaning of statutory provisions to commit a decision about when illegal immigrants are subject to expedited removal to Homeland Security's sole and unreviewable discretion. But Judge Jackson concluded she could still review the agency's decision because this language didn't mean the decision was, quote, committed to agency discretion by law, end of quote. By reaching that strange conclusion, she gave herself the power to oversee Homeland Security's decisions about expedited removal. And of course, the D.C. Circuit reversed this ridiculous ruling. I think there's been bipartisan frustration with how little nominees say and how candid they are in hearings. But Judge Jackson wasn't ready to answer a number of questions other nominees were willing to answer. One senator asked Judge Jackson about the judicial philosophy for 3 sitting justices. She said she wasn't familiar or had a hard time or didn't have time to research the issue. This is a question asked in almost every interview for interns and law clerks around the country. We don't expect a nominee to say that they will agree with a specific justice 100% of the time, but it's not asking too much that a nominee be able to explain the justice's approach to the law and where they might differ. Judge Jackson also said she didn't watch and wasn't familiar with the Kavanaugh confirmation. That's pretty surprising for a sitting federal judge who worked in the same courthouse as then Judge Kavanaugh. As a member of the committee, it's hard to satisfy everyone. I've had calls to my office complaining about Senator Durbin saying good things about me, and they argue that I didn't say enough about Democrats' treatment of Kavanaugh and Barrett. And then I have Democrats who are saying I was too mean to the nominee. Throughout this process, I've focused on thoroughly and fairly assessing Judge Jackson's record. I think I've done that. We need confidence that judges will interpret the law as they're written. Judge Jackson's reinterpretation law I've helped write doesn't give me that confidence. Thank you.